fixed up, Mr. Rosales.
I'm ready to go.
Okay.
Good morning. May it please the court. Kurt Rosales and George Baca with Baca Law Group on behalf of Phylis Heid. I'd like to reserve 5 minutes for a rebuttal.
Sure.
So we're here to ask the court to review an order denying statutory appellate fees, where FIGA affirmatively denied Mrs. Heid's claim, then entered into a settlement agreement, and the trial court refused to grant attorney's fees. I'd like to go through some of the facts of the case, as Miller, decided by this court, is controlling. And given Miller, Mrs. Heid is entitled to attorney's fees. So Mrs. Heid claim arose in 2010. She submitted a claim to HomeWise, who was the original insurer. HomeWise did some investigation through a company called BCI, and their reports indicated there was no sinkhole damage at the property. Thereafter, HomeWise became defunct, and FIGA stepped in. When FIGA steps in, they again consult BCI. BCI again decides that there's no sinkhole damage at the Heid property, and on March...
In particular, aren't they looking for structural damage to show evidence of sinkhole involvement?
Right, so I know that...
isn't that kind of the issue? In other words, if there are sinkholes in the immediate area, but they can't identify any structural damage to the specific property, then they don't deem it a covered claim. Is that a fair statement?
Sure. So I think FIGA's position on the covered claim issue is their position is that a covered claim only becomes a covered claim once they agree with the science or agree with the report that deems it a covered claim.
Well, did this, I'm sorry, did this report, the first report, did it indicate there was structural damage to the home on the property?
The first report does indicate that there is some damage, but they decide that the damage to the property is not a result of sinkhole activity, that it's, and I believe it says, quote, other, I can look. But
well, isn't that, I mean, experts can reasonably agree or disagree on such things, can they not?
Of course, and we'll see, so later on, years after, in fact, Mrs. Heid is forced to conduct her own investigations, and so she hires a company called FTE. FTE looks at the old BCI reports as well as does their own investigation, and they determine that there is, in fact, sinkhole damage. Further down the road, another company called with Nettles, NTS, they do a review of all the reports, and they conclude that the BCI reports themselves contained evidence of sinkhole damage to Mrs. Heid's home. So it gets us into that same question. While you do have experts that disagree, when you're in the litigation context, the reports of the experts, there's no presumption of correctness there. So when you play this game where you can move around when a claim is a covered claim, it leads to issues. So one of the issues it leads to is FIGA is in a position where they can basically say, we will never concede that a claim is a covered claim based off the science. They can push claims all the way to a jury verdict or a settlement in this case or in other cases, then concede that there is a covered claim and never be liable for statutory attorney's fees, which in and of itself essentially repeals 63170.
But then we sort of have to analyze the decision in De La Fuente and our decision in Miller and trying to reconcile these two statutory provisions, one of which clearly says fees are not recoverable under any circumstances in this situation when FIGA is involved, the other of which indicates that fees may be recoverable. So Miller tells us that in order, Miller tries to reconcile this and basically says there are circumstances which the insured could potentially seek to recover attorney's fees under his or insurance policy and related for testing to repair of sinkhole losses. So even Miller seems to indicate they're talking about under the insurance policy, not FIGA per se. Help me with your interpretation of that language.
So my interpretation of Miller is Miller goes on to continue, and they say that the language that has to do with the testing and those provisions comes into, says such as a dispute between the insured and a contractor who is making repairs to the property damaged by the sinkhole. So I think what it comes down to is the fact that 63154 is a definitional statute. It defines by its exclusions what a covered claim is. 63170 allows insureds to receive attorney's fees, but they're not receiving attorney's fees as part of their covered claims. They're receiving attorney's fees when FIGA denies a covered claim by affirmative act or by, with an affirmative denial.
Something other than delay.
Something other than delay. So I don't see 63154 having any effect on the attorney's fees. It's isolated. It just tells you what a covered claim is.
So the whole purpose of FIGA, when the legislature enacted FIGA, was to basically protect the policyholders if their insurer went insolvent, which happened in this case. And it's a creature of statute. And therefore, we got to strictly construe the statute and what the intention was. And the intention was to basically allow these people to repair their homes in the case of a sinkhole loss, not just to write them a check and not to allow them all the other causes of action they might have under an insurance policy. It was simply to take this limited pot of money that the legislature makes available to protect homeowners in Florida in the event their insurer goes belly up, to simply fix their homes. So it's difficult within that construct for me to read in some expansive intention to allow for attorney's fees or testing fees or things of that nature, which at least one of these sections clearly says is not recoverable, not available.
And I agree, but I think that the difference, or what's differentiating, is the fact that if we are going to look at the intent of FIGA, we do have to look at that alternative to where. So, for instance, in this case, we just look at the facts of this case. Given that framework, Ms. Heid would never have been able to recover. She was required to hire her attorney. She was required to have that attorney on a contingency basis hire not one but two separate engineers in order to develop the science which led to her to be able to recover. So if we were to accept the premise that FIGA is not to basically pay for anything other than the actual repairs, and again, given De La Fuente, they only pay to have the repairs completed. They don't write a check to the insureds.
Irrespective of these flashing lights, we really are in a court, not in a nightclub.
It's on you, your time's up signal. No.
Well, I'm having fun up here.
This happened actually yesterday? Yeah. So we don't know what's going on.
So I just think that if we are going to look at the intent of the FIGA Act, I think, and then we look to the plain language of the statutes, that's how we arrive at a situation to where, look, FIGA is going to pay to have your home repaired, but at the same time, given 63170, when FIGA denies your claim, which is a covered claim, and in this case, FIGA admits it was a covered claim.
But at some point, they acknowledged, I mean, they initially denied it when they had conflicting reports, and of course the favorable report was the expert hired by the homeowner, which undoubtedly causes them to look at it skeptically, right? I mean, isn't that a fair assessment of what they would
Sure.
do? They probably did. But when they got the third report that sort of said, you know, we've looked at them all and we think there is, they stepped up to the plate, didn't they?
I agree, but Your Honor, if we take into account the fact that the home was repaired based off of the BCI, which was FIGA's experts' 2013 remediation plan, I think that's evident that that plan, which was established by FIGA's expert in 2013, so more than 2 years before Mrs. Heid hired her own experts, that plan was used to repair the home. So how do you have a remediation plan that can be used to repair a home from sinkhole damage when there was no sinkhole damage, given your own report? And that's why we have the later reports, both the FTC and the Nettles report, which determined that given the data and the science in the BCI reports, there was sinkhole damage to Mrs. Hyde's home.
So then, under that sort of analysis, in any sinkhole case, the first report out of the box, whether suspect or not, if FIGA does not agree with it and pay, your position is they are denying a covered claim.
So no, because what would happen is the same process would unfold, where you would have subsequent experts come in and look at the home, and if
Isn't that kind of what happened here?
Right, but here at the end, here we have a confirmation that we had a covered claim from the get-go, and if
I guess, except for there were two conflicting reports, and apparently not a visually major evidence of structural damage in a home. In other words, it was a darn close call, which is why you have two experts taking two different positions on it.
Well, I'm not sure I agree it was a close call, because even if we take a look at those BCI reports throughout those first couple years, we have some reports, we have some instances where they do the borings, the SPT borings, and half of them show up that they could be issues where they lose water in the boring samples. Sure, but the end result is that FIGA does admit that it is a covered claim, and the reality is it was not a covered claim at that point. It was always the damage was there when the initial claim was made. And I think if we go back to the FIGA statute and we look at the language of the statute itself, and I'll pull up what specific statute I'm looking at. If we look at 631-57-1, it says the association shall be obligated to the extent of the covered claims existing, and then A, prior to adjudication of insolvency and arising within 30 days after the termination of insolvency. B, before the policy expiration dates, if less than 30 days after the termination, or C, before the insured replaces the policy. So at no time, even given this language, there's no statutory language that states a covered claim becomes a covered claim when FIGA says it becomes a covered claim. We'd have to be reading that language into the statute.
See, it'd be clearer if FIGA had denied this claim, you'd gone to trial and got a verdict in favor of your client, right? We wouldn't be having this conversation, would we? Because that would have been a denial of a covered claim by affirmative act, and FIGA was proven wrong in a jury trial. The difficulty we have here is we have what is a fairly typical scenario where there's not overwhelming evidence of sinkhole damage, where you have experts that don't agree, and FIGA is being judicious with its limited pool of resources that it's given by the legislature to bail homeowners out all over Florida when their insurers, go belly up. So they were being thoughtful, careful, judicious, and in the end, without going to trial, without engaging in litigation. They said, hey, you're right, we'll pay.
Well,
It's hard for me to think that the legislature intended to punish them in that scenario. And if they did, then what scenario is going to be okay for FIGA? And I go back to my original question. Must FIGA basically pay up for the first report that comes out of a box on a house that maybe isn't visually, structurally impaired, which is what they got to look for, where they think, oh, this is a close call, we don't agree with this report. Well, if they don't agree with that report and get a subsequent report, have they denied a covered claim and now obligated for fees under these statutes? I just don't think the legislature meant to do that to them.
So two things, Your Honor. I think firstly, we do have the equivalent of a jury verdict here. We have FIGA admitting that this is a covered claim. We have a confession of judgment. We have...
Well, in your view, a confession of judgment, but again, because they basically with the third report said, okay, I think you're right, we were wrong, we're paying.
Well, I mean, the 4th District in Messina agrees that FIGA, when they go to settle a claim after the same exact, or not exact, but a substantially similar situation, when they enter a settlement agreement similar to the one that we're in here, that we have a confession of judgment. So I think that we are in a similar situation to your hypothetical where you end up with a jury verdict. And I think, and I'll repeat, as far as what FIGA is to do, when they're approached with a claim and they have an initial report, and again, it's their initial report, so I get, the same thought process could be applied to both parties here. Obviously, homeowners are going to have limited funds, and obviously by denying them their attorney's fees, it's a punishment in the same way suggested that FIGA is being punished for having to pay attorney's fees when they affirmatively deny
So
a
what part
claim.
of De La Fuente do you think supports your position? Because De La Fuente seems to clearly say you're not getting fees.
I personally think De La Fuente doesn't even attempt to look at the same language. So De La Fuente says you are not going to be paid the monies to repair your home. So we go back to the definition of covered claim. De La Fuente says we are not going to write you the check for whatever the bill is to repair your home. That is completely separate from 36170, which deals with the attorney's fees. So prior to the amendment, prior to De La Fuente, an insured would receive a check for, let's say, X amount of dollars. At that point, an insured could either repair the home or not. So the legislature said, look, we have insureds receiving monies, and they're not using it for what it's meant for. So we still have these homes that are damaged, and they're not being fixed.
But the legislature's, I'm sorry.
Well, I hate to interrupt you guys.
Okay, we're having a nice time.
But we're into your rebuttal time, so do what you wish.
Well, I'll end there and reserve the rest for rebuttal.
That's fine.
Thank you.
Can't get a word in edgewise.
Oh, that's all right.
Dorothy D. Fiore for FIGA. I don't get to reserve any rebuttal time, right?
Yeah, that's right.
So FIGA does want this court to affirm the trial court's determination.
Can I kind of jump in here, do you mind?
Absolutely.
You can tell I'm very talkative about this because I'm really trying to drill down on these two statutory provisions in De La Fuente and Miller and trying to reconcile all that. I mean, at the end of the day, it seems that there was a door left open for recovery of fees in these situations. But I don't think you agree with that. You think Miller was wrong in attempting to leave that door open. Am I correct in that?
You are correct.
Zero right in on that and tell me why.
Absolutely. So first we start with the plain language of the statute. And the plain language of the statute says very clearly that FIGA does not pay fees in connection with a sinkhole loss. That is a very broad phrase, in connection with.
But that's in the context of the definition of a covered claim,
It
and
is
not
within the
necessarily in the context of litigation.
Well, so it is within 631-54-3C, and it is, which is the definition of a covered claim. But if you look at the language of the way that has been set up, then you have it very clear about what they're going to say FIGA's obligations are, because it talks about public adjuster fees. It talks about paying, how they're going to make the payments. So could the legislature have drafted that perhaps a little better? Yes, I think they could have. But you're looking at this statute that very clearly says a covered claim does not include anything payable on a sinkhole loss except. And then they've carved out very specifically the cost of testing and the repairing of the property. And if you think that's a little confusing, then what we have to do is go back and look at why the legislature might have done that. But I don't think it's confusing. I think they said very clearly, these are the only two things that FIGA will be obligated to pay, and everything else is now off the table for FIGA. And when you look at the legislative reports and the data call and all the things that prompted them to draft this legislation as a whole, not just related to FIGA, but as related to the entire industry, but also because of FIGA, you will see that that is in fact exactly what they were trying to do, is say the only thing we want the money spent on is proving that the science shows there's a sinkhole, so that we don't have sinkhole damaged property left out there that actually isn't sinkhole damaged, so that we don't have homes that are left unrepaired, et cetera, and so that we don't punish the insurance companies or FIGA from engaging in rigorous scientific inquiry to make sure we have sinkhole claims. And so then they put it there. Could they have put it somewhere else? They could have. But what they did was say FIGA on a sinkhole claim is only going to pay for the testing and the repairs. And by the way, they're only making those payments to the people who are doing it, so you can't take the money and run. And so that's...
So then, do you think that had this case gone to trial, and had there been a verdict rendered against FIGA, FIGA still would not be obligated for fees?
Our position is that the 2011 definition of 631-54-3C says that, yes.
Okay.
Now,
So
Miller
it's
obviously...
absolute. And then in this particular circumstance, this poor lady went through a whole ordeal to try to finally get paid. She went through two attorneys, finally had to take one on a contingent fee basis. So FIGA steps up to the plate after 3 reports and a protracted period of time. She now, because she's got to pay her attorney, doesn't have enough money to fix her house. So it sort of defeats the whole intent of FIGA.
Well, no, actually it defeats does not. It furthers the goal of FIGA. So let's start with the facts. The facts show that she made a claim because she saw visible damage to her home. The first investigation done by HomeWise came back with a report that says there's no structural damage. Now, if you look at those legislative reports, one of the big things they did in 2011 was fix the definition of structural damage, because a lot of these insurance companies came out and said, oh, it's not structural damage, we're done. They didn't do the testing. They didn't actually look. So they said, we're going to clarify what it means to be structural damage, so we stop fights over that, and then we're going to make sure you do better testing. So Mrs. Heid said, well, I think you need to actually do the testing. The very first exam did not involve geological testing. So then they said, you should do geological testing. And they did. All right, so then the BCI borings, they dig down in, they look at the soil, they look at the limestone, and that's everything. They said these are not the conditions, these geological conditions do not constitute sinkhole activity. So there are 2 components to this, both of which in the beginning with HomeWise Preferred were not in favor of Mrs. Heid. Now FIGA, when they took over the HomeWise Preferred claims, they did not pursue the structural damage issue whatsoever. They were not going to get into that litigation, and they were not going to fight. The only issue FIGA looked at, because they looked at the purpose of this statute, was, is the science there to show there is a sinkhole? So they were looking at the geological and engineering discussion. So the first round of geological testing said no sinkhole. She didn't agree, so they had that peer reviewed. So another set of eyes looked at the geological data and said not a sinkhole. Then they went to neutral evaluation, and they said not a sinkhole. They did more borings. I think they came out to her property at least 3 times, if not 4, to do actual digging in the ground. I've never seen so much borings and testing done of the soil.
Well, I don't think there's any question that FIGA's refusal to pay, was in good faith. There's no assertion that there's any bad faith going on or, insufficient investigation or anything like that. But 631.70 doesn't talk about good or bad faith. It talks about this is when you're entitled to attorney's fees. And if it's you deny by affirmative action other than delay a covered claim or a portion thereof. And it turns out this was in fact a covered claim. And FIGA, I think, conceded that it had denied the claim by affirmative action, so that's not an issue anymore. So what this boils down to is, was this a covered claim all along, and and FIGA just didn't realize it? Or was it only a covered claim when FIGA said, okay, yeah, you're right, now there's evidence to support that? I mean, either it's a covered claim or it's not. So in your opinion, when does it become a covered claim?
When the science establishes that, in fact, there is a sinkhole there. And the science did not establish that until the testing done by NS Nettles in 2015.
Okay, and what is your basis for saying that it only becomes a covered claim when the science is there to back it up?
Because it's limited resources that FIGA has to implement, and they cannot just go randomly trying to remediate below the ground when the soil conditions and the science doesn't show that, in fact, that's going to cure the problem. So without knowing where the problem is and how to fix it, they can't do that. Especially now that there's a mandatory repair component to the statute. Before, if you just needed to say, okay, look, looks like it's a 50-50 shot that would get a sinkhole, so we'll pay you 50% of the claim. That was one way to approach this. But now it's like, well, it's a 50-50 shot, so what do we just come out and start randomly drilling grout holes? So that's the problem, is when the science isn't there, FIGA doesn't have a claim that they can just use the limited funds that are available in the insolvent estate or through assessments in order to just simply pay people off.
Well, how often does it happen that you've got test after test that says that there's no sinkhole damage, or it's arguable whether there's sinkhole damage, and then suddenly, conclusively, X number of years down the road?
Well, I'll be in all candor, most of the time after the first round of testing from the insurance company says there is no sinkhole, that's when the insureds go out and find an expert to come out and do that, or they demand neutral evaluation. So I've never seen this many rounds of back and forth with peer reviews and additional borings and things like that.
So this is
very
not the
unusual.
no run of cases.
So typically what you would see is the insurance company, if their testing did not confirm sinkhole damage, then the insureds would hire their own geologist, and they would potentially have conflicting data. Sometimes there isn't conflicting data. I mean, sometimes the testing shows there's sinkhole damage right off the bat. Sometimes the neutral evaluator does different testing or looks at the science and says, no, that your geologist read it wrong. And if someone just says your geologist read it wrong, I mean, that's not additional science, which is all Mr. Galati did in this case. Mr. Galati did not go out and do his own testing. And in fact, his opinions have been discredited by the courts on a Daubert hearing to say that the reasons for why he felt there was sinkhole evidence have been discredited and are been determined to be non-compliant with the Daubert standard. So, up until NS Nettles went out, and by the way, that boring that supported this was a completely different location than any of the others. So that's, when we look at this statute, if you look at all the components of what 2011-39 implemented, one of the things they implemented was this desire to have this stringent standard for testing, to increase it and make sure the companies were doing it right so that there was not false negatives or false positives. And when they did that, that part of that same statute that said, go get the science, and they also said, and let's not punish the insurance companies for doing that. And so when FIGA just kept looking at it and trying to find the truth, so to speak, then that's when the legislature said they should protect FIGA. And I think that whether it's a covered claim or not, this statute says that the FIGA should not have to pay. Now, if you look at it under the Miller ruling, let's say Miller is correct interpretation of this, then they've created this testing time period. Well, that's what we were engaged in from 2010 to 2015, apparently, because everybody just kept drilling and looking and drilling and looking, and they kept...
Yeah, I don't think your position is inconsistent with our holding in Miller. That's why I was surprised you spent so much time telling us we need to recede from it, because it doesn't hurt you in this case.
We don't think it hurts us in this case, but we do want this court to revisit Miller, because we do feel like that did not honor the plain language of the statute that the legislature gave to FIGA and the other insurance companies to try and make these sinkhole claims get better, to try and protect the tax base. They've stated very clear overall public policy that they were trying to accomplish. And so if we take parts of the statute and we cut out the parts that they put in that were to accomplish that purpose, I think we go back to defeating that purpose. them.
I mean, if FIGA took an outright denial in the face of overwhelming scientific evidence of sinkhole coverage,
I think I'd have a whole completely
I
different.
think Miller at least leaves that door open for somebody to get fees for a wrongfully denied claim by something other than delay.
Right.
I don't think that's an outrageous position to take on these two statutes.
I mean, from the beginning, when FIGA saw what the legislature wanted, they have taken extraordinary steps to try and do what they can to get the homes repaired. They refused to accept the HomeWise Preferred's denials for structural damage. They went out and did additional testing if they if it wasn't done. They got peer reviews to verify their own testing. They asked for neutral evaluation, or they told the policyholder to ask for neutral evaluation so that they could get a third set of eyes looking at it. They went to the receiver and asked for permission to pay more than the policy limits, but up to the statutory cap in order to effectuate the repairs. They've done as much as they can to make sure this claims handling is done in good faith and is done in ways to accomplish this legislative repairs mandate. And so the argument that FIGA could do all these things is belied by FIGA's own actions and the way they've handled all of these sinkhole claims that came in. We have a number of sinkhole cases with Mr. Kling's office and with another attorney in which the attorney fee issue is still in dispute. And so if the court is inclined to not feel like you're in a position to reverse Miller or revisit Miller, we would ask that this be considered en banc or that you certify a question, because we have 10 or 15 cases in our with Mr. Kling and another 7 or 8, and I think I'm possibly looking at about 20 more cases in which the attorney fees and the repair mandate are up in the air, and we really do need some guidance from someone as to whether or not the plain language of 54.3c is whether FIGA's right or Miller was right. And again, under Miller, we still think in this case we were during testing. And so that by the time FIGA accepted this, it was still during the testing and investigation. If you look at Ehrlich was not a sinkhole claim, but I think it was a hurricane claim. And they had to file suit against FIGA. And they make very clear that if FIGA is still investigating the claim, then they accept it even after suit is filed. That's not a confession of judgment, and it does not operate to trigger fees. So in this case, we accepted it finally after they came forward. And did we have to file a motion for summary judgment to make them to come forward with evidence? Yeah, that's what it took, because there was nothing until then. So we think that this case supports no fees. And again, we'd like to, if you think that there is potentially should be fees here, we'd like to see a little guidance on how to interpret the two statutes. Thank you.
I promise not to ask you any.
Yeah,
Okay.
right. We'll see what happens.
I accept them. So I wanted to kind of bring up another hypothetical. So under FIGA's position, and I believe under the position that you were asking me about, Your Honor, if FIGA denied a sinkhole claim, based on the idea that the policy had lapsed, and so there's no testing involved here, and that goes all the way to trial, and a jury finds in favor of the insured, and in fact their policy had not lapsed. Under FIGA's position, they would not pay attorney's fees. So I think given that scenario, and then given the plain language of the statute, these are the reasons why FIGA can and should pay attorney's fees under 631.70, and I'm cautious because 631.54 again is a definitional statute. All it does and all it purports to do is explain what a covered claim is. And again, FIGA does not pay these covered claims to insureds. They pay only, according to the statute, to the contractors directly, and they're paying to have the homes repaired. They're not paying directly to the insureds. Another thing I wanted to bring up was FIGA also contends, and that there's an issue between De La Fuente and Miller. But if we look at this court's opinion in De La Fuente, and then we look at the Supreme Court's opinion in De La Fuente, both courts only went to the plain language of the statute. If we look at Miller, Miller only went to the plain language of the statute. Given that, we don't get into the legislature's intent and history. We don't get into these reports. We don't get into any of these things, because that only comes in if we find that the statute is ambiguous, which this court and the Supreme Court already has declined to do. And again, I want to direct you to 631.57, the only part of the FIGA statute that says anything about when a claim is a claim. And if we take a look at it, it never says anything about science. It never says anything about any of these things, because again, given the situation to where you have a claim and FIGA denies based off of the being outside the policy, or FIGA refuses to believe the engineers, you have a situation to where the statute is silent on any of those situations. The only thing the statute tells us is that we have a claim, and that FIGA should be obligated to the extent of the covered claim existing prior to adjudication, and all these other time frames. The last thing I wanted to talk about was, when it comes to a claim being a claim, it's always a claim. And I think that this case really solidifies that point. We had BCI doing their testing. We had the FTC report that came and took a look at those prior testings. We had Nettles. The Nettles report specifically says that they took a look at the data from BCI. They took a look at the conclusions that FTC made, and they said that given those prior investigations at the property, there indeed was sinkhole activity. There indeed is a covered claim. With that, we'd like the court to reverse the order denying Mrs. Hyde's motion for attorney's fees. Thank you.
Thank you, Mr. Rosales. Nice job, guys. That was
Yeah, your briefs
very
and
interesting.
arguments were excellent
Very
today,
good.
and we needed that, and I appreciate it.